me say petition na akwa abontin. Ya rechi 20,000. Na mpese mbisa se ebetimi abua kesi kakra anase ehun here.
I mean, what is in the petition? Tibia move for the binam saka.
Hey,
I've not received anything. Tisebia.
mama. Ah.
Yeah, I go to for the mommy number no why.
I go to move fama no kenken bi na emu odenti because
But they, what is this seeking to? What is the petition seeking to achieve, if I may ask?
So we put. Sorry, go on. You can speak. Sorry.
Go on. If you want to say something.
So the intent is to essentially petitions are set up so that you get lots of public call. Yeah, we've lost the.
Who concentrate what the way?
About my
Mr. Macho Man. So camera.
Hello.
Is it okay?
Yes, it's okay. So the purpose of petition is that you often do it to a public body, is that you show a lot of public interest because public bodies are there to act in the interest of the public, or they take actions on topic or situations that the public have an interest in. So you petition and you get enough signatures from the public for a petition. And if you reach a certain standard, then the government body, in this particular petition, we are seeking support from the German embassy based in Ghana to assist Akosua Serwaa with whatever she needs for her appeal.
Oh, that's a good one. That's a good one. It may not affect any court proceeding, but it can also produce another angle of support. That's how I see it.
Okay.
It may produce another. A bit me cry at trigger embassy, to now decide say, oh, now say the panel are German citizens. So yeah, mudie irene ma ene ye yi tino ye befa body nako ne ro irene ma ko ne omoyi. Yeah, it can trigger that part. So me pacho I go to afford mami na me sign be why.
That's it.
That's it anyway.
Ola Michael.
Yes, ma'am.
Me pacho initially no me say yes na verdict ni 76. Me pacho mami no ko yi bi free mu na 40.
Miss Van Brown. Pacho, hold on. I think so but too experience with
maybe say we me pacho Shanice. Maybe say
experience in
Pacho ya ma.
Why me then short and na me bisa una. Why ne verdict ni 76 na fe dey den mami no okotena se dwene hu yi bi free mu na ba be say 46 and answer bi bisa.
Okay, so ABC is 74, ABC is 76. A normal sometimes obetenase no assign try to summarize it a bit more so that they are any too bulky for reading. Minimum more who say 76 and 74 no. I was of the opinion say on one name it or can say oh the ruling is about 74 pages. ABR the font sizes or the throw I could do 74 no. Maybe or TT font no so. Emma now it got to be 49. Yeah, 49 as I see it. And now sometimes I know ruling nibi waha the interaction and answer interrogations between lawyers and witnesses and they try to produce that as part of the ruling. Or they make reference to those things as part of the rulings, Yeah, and also to me, a year because my kind ruling be a year about 336 or 35 pages. Oshima interactions a course questions are lawyer be a bisa witness be a nina ya producing. But when one yenisa, one fa so much of and say kakra bi no show here. So I'm sure say we need those interactions in be brief ma pages no and aba from or maybe in the font no what it is so that it will be a bit more.
And yeah, what the born in the bar wanting work people.
Me person me bemu kakra in respect of that.
Okay. Lawyer Pacho boy.
Pacho, I think say my main congratulate you na me salute you. We am here video trending. I'm impressed. I think say I've also had an occasion to do with some grandma we were Ibia say was the banner. And so yes, or some supermarket view.
Hold on. Opportunity.
Yes.
That's my mom. That's my blood mom.
Oh, good. Yeah, I'm turning the bone come up when I was in school.
Oh, so who many mabons and mammy no?
No great.
Yeah. Who many mabons and mammy?
No great. Very nice woman. But the mind and
yeah.
We've been hanging along for a while now. But yeah, that's it. So going back to question now, Lady Nibisa, I think it's already judgment never out now. It doesn't bear certified stamp.
Yeah.
I believe since I could see apply for copies. And no about font size
bulkier than this one.
Font size in the year 14. And space in the so Omuma it be a 1.5 and I say 2. It's very brave, but the any who so far near I think said the low platform copy. Omo reduce size in to 12. No, almost space in almost reducing. So
I think it's about 1 or so.
Tiaban sana a bit compressing. It is a before say a bit young cocasibia why something and I say we be from near other things. And I want us to wait and I say like we see and I say yeah mommy apply for certified copy from the registrar. That's around 70 column now, then we can insinuate the
you're right.
And so that is it. And I must say to you submissions in Kakra in respect of the way my ministry shoot it down your certificate. Over session 161 now or rely on it now. You were section
Evidence acting, right?
Evidence acting, yes.
Okay.
Or rely on 1 and 2.
Yeah.
But in the training create exception. But because nobody can make up the mind, 1 to Nabianco, because a trainer 1613 subsection 3 no say if a reasonable opportunity is given to the parties to investigate the authenticity of a foreign official signature, the court may, for a good cause shown, order that it be treated as presumptively authentic without the certification.
Exactly. So, last Saturday in my analysis on the ruling before it came out, I mentioned this one, the third part, that if we had given enough time to authenticate this whole document, I'm sure we wouldn't have arrived at what we are now.
So basically, you see, justice delayed is justice denied. Similarly, justice hurried is justice buried, and that is what we are experiencing now. Because Senkema lawyer Kusi timer, there is no way we couldn't have gotten people to come and testify in respect of foreign law now, or can say a matter of fact. So someone an expert need to come and lead evidence, near cross-examining all those things. Because I think can take judicial notice from the onset in pleadings in now must be saloon by no and in Germany. And you can take judicial notice Germany or customary marriage.
Of course.
Polygamy in you.
Yeah.
If we to me say warrior or even in the absence of the certificate, and I say in the absence of its authenticity, or now I can say any certificate in quantity prove marriage. So where it is convenient for her, and why state say you can be holding the certificate, but there may be no marriage. Or discuss say issues about say one party is already pregnant for another person, and I say one person is they are out of deceit and answer fraud, near other things I'll mention here. So
You say wabeje mpena bebre ya tumu asaware.
you understand. And so going on that tangent, you know, would you to say we wait to make with a certificate, but now on your the same way you can also be a wife without holding the certificate. So I believe say she has already made up her mind. Say biblical King Solomon judgment in no person or deba. And we also give her a leeway.
Yeah, we give her a simple way to have that.
That is the thing. So I believe that once you are going on appeal, people with good conscience will understand that won't mean for technicalities when you say this is the deal.
Yeah.
So I even feel say on appeal, if we work so hard that this case can be retried. Appeal judges limit mark say based on the way a case being in a court, nobody should benefit from the judgment. Yes, I'm hearing. Or meet master the case in the back to high court, someone taking the time. Because you can't tell a plaintiff lawyer say, oh, leave these ones to me, I'll handle it. Only for you to come back and rely on those little flops. No. Now the actual judgment are in favor of. And there was no point in hurrying to finish the case in record time.
Yeah, what is the point? Really, what is the point?
So 1 month now, and a lot of cases have suffered adjournment.
Exactly.
We are applauding her, say, why are they? We other cases are non case and Mrs. Basu in the quarter. So, make in respect of what may be in them.
No, in respect to the duration of the assembly. We have to accept the fact that we are there. But it's, like I said, make waste at times.
Yes, other cases have suffered. And we know on record time. But be that as is me, so well, injunction application, one grant is injunction or grantee in poor. And I can say, oh, because any punishment freedom, because of injunction, you to be in seeing any other things. But once I want granting injunction, case na it had nothing to do with the funeral.
Yeah.
Beyond say why in and one anyway. So we could have taken our time to handle the case. Because we a case now day in day out, you get fresh ideas. But
this instance, all the pressure took lawyer also to produce what he has to produce within a short time.
You understand? And getting other people from Germany and other things to certify this animal, it did not help.
Yeah.
And so on appeal, I say, oh no, remedy case in the back for retrial. We will not rule out that option. Because
it's possible.
To be honest, this judgment is not something we should let it stand.
No.
We shouldn't. But in submission,
lawyer for Joe Balami.
Yeah.
Lawyer Joe Balami.
Mr. Robert Obi.
Oh,
I think so. Yeah.
Maybe question why?
Yeah, okay. Jumana, you can talk.
Yeah, just joining what Joe just said, and I was discussing with Joe yesterday. The funny thing about this as well is that if you remember that divorce letter, someone mute themselves, please. That divorce letter that was tendered by the defendant to as part of the counterclaim that Daddy Lumba and Akosua Serwaa had divorced by her bringing her drinks. And the funny thing is, if you read the content of that letter, which was sent and was relied on, and the judge also relied on that letter, and if you understand anything to do with, what documents that should be submitted and what kind of weight you should place on evidence, a statement that's been made many years before the hearing, in the letter, for example, and in that letter, according to the defendant who submitted it, in that letter, she discussed the fact that she's brought the drinks back, but she also discussed the fact that her and Daddy Lumba had an ordinance marriage back in Germany, that he should agree for them to both dissolve. Am I making any sense of that? So,
yes.
The judge should have taken the judicial notices.
Exactly. So the fact that she says in her judgment that there was no divorce whatsoever between the two, and the content of that letter specifically was clear that there was two marriages. The first one, 1991, and then ordinance one. And she's saying, okay, now let's go and divorce through the ordinance. That was clearly a consistent statement that had been made and accepted. 2018. The judge relied on that letter.
No,
Okay.
no, I think she
And there was a court evidence from the defendant.
she actually
but
did
sought
not
not to
rely
use the
on
part
that
of the
anymore.
letter that supports.
Because
Oh, she did. If you read it, she relied on it and said it was not.
reading it,
She said that it was not sufficient.
yeah, she said it is not a sufficient grounds to accept that there was any sort of divorce. One, because
Exactly.
even if say the sacra by no, you know, it was in two parts. Intention to divorce cannot, as she meant, be accepted as divorce. And even if she
Ola,
was
that's
in
exactly
sanso
what
by her, even if she was in sanso by her, man or ye didn't buy Mr. Is it Kantanka or something? Helped her to understand that what in some pokra bar and yes, or the buyer near the families try to resolve and reconcile the two of you, give you time. But when you come back again, now the Sunday say Basu Mokoya Nye Mode Muntimi Waribim, then the family will have to sit again to deliberate on the issue before say the part of person will fly warimino yebeje or yebeje nensa. She
Ola,
explained that
exactly
one.
what I'm saying. And I read all of that, which shows that she had in front of her evidence.
Yeah.
Yes, there was
Evidence that
sufficient
proves
evidence that
listen,
it was
evidence
an
that
ordinance
proves
marriage.
two marriage. Okay,
Yes.
one was traditional and one was ordinance. She relied on it, and what she said was it was not the evidence through the letter of what had happened. Even if you accepted the facts at the time, it wasn't sufficient based on what we had learned to
Yeah.
dissolve any marriage. Okay, in view of that,
Joe,
if you're going to rely on the content of that letter,
Mama, can you mute yourself, please? Thank you.
then why ignore the part that consistently support the evidence that there is a valid ordinance marriage, and not even look at that part of the evidence, which strongly suggests you have all these information, because she relied on that evidence. Not like she said she was not going to look at that evidence at all. She relied on it. She discussed the content of that letter, but she missed the key part of it, which the parties have accepted that there's two marriages. And before she even brought the case to trial, she is saying we've got two married. We married in Germany. We did this, and does that make sense? So in not often when I go to court in the UK, in the court of law, that would be what we regard as consistent statements in a document, which you put strong weight on it because that statement was made years before this court case. So the likelihood that you would have invented the facts in that letter to support the case is minimal. So not only have you got all these documents and certified document, a letter from the embassy, all of this stuff, you also got consistent statement in document form of an intention to divorce, but to divorce not only under the tradition, but also to divorce under ordinance.
Yeah.
And yet she made no mention of those key evidence that should have given her sufficient grounds to say the standard of proof, which is the balance of probability, had been met. Sorry, just wanted to just add that.
I get it. But the whole ruling, if you read it back and forth, you get frustrated along the line. Sometimes you might even get upset. But this is what we have, and we need to now focus on how we're going to, position this whole appeal process, what need to be, filed. And I see that there are some chances, a lot of chances, if the right things are done the right way. So I don't feel, it's lost yet. I don't see it that way.
Okay. Jumana, please, are you done with your questions?
Yes, I actually overstepped. I had finished with my time.
Okay. All right. PSA.
Okay.
Patch, remember 3 minutes. Why? Because request no more than 40. You, Mr. M. Why?
Okay, that's fine. No worries. That's fine. Uncle Ola, good evening.
Good evening.
Thank you very much for your support. To be honest, I like your like unim no or knowledge any support concerning this issue. Even how I will see to boss a church the last time Saturday, UTV, now my ear very proud of you. Say, you did a good job.
That's
My problem is say, lawyer could mention say, other, defendants ne lawyers kasa fa marriage certificate no ho no. Lawyer could say or catch judge ne say or person ka o invite obi maneba from German embassy. Na nipa kro ne ba na nipa no ebeye part of the witness for no na oba ebechiechiri mu said the marriage certificate no esitie ne how a omusiye no because enye kro bia so